Your job descriptions tell you what you're supposed to be doing, so why ain't you doing that? The Constitution of the United States pledges the federal government to protect treaty rights as it is included in the supreme laws of the land. Constitution, Article 6, Clause 2. We're going to get to that a little bit later, because this is why they don't have jurisdiction over us Moors. They can't adjudicate any claims as it relates to us Moors because we're outside of that jurisdiction. Right? The state courts can only adjudicate cases between citizens of its state. Can't go outside that. So if you ain't a citizen and they didn't produce anything in the record to substantiate their claim or presumed jurisdiction or implied jurisdiction as you a citizen, they're not withstanding. Then what makes your unlawful detainment? It makes your unlawful detainment kidnapping. So Moors all over Morocco have been kidnapped. I've been kidnapped 18 months. 19 total. Why? They don't want to admit they're wrong. They don't want to admit they got to give you back everything they stole from you. They don't want to admit they are inferior to you. They call them inferior courts. The Treaty of Peace and Friendship is not with this document. I need the Treaty of Peace and Friendship. You might not be able to find it. It'd be easier if I go get it. Because I'll have it in the bag. Huh?
The bees on. I think you want to
Burn it up on it.
Okay. What's this code again?
6272. The Treaty of Peace and Friendship. I ran out back to get that because I thought I had it. Right? And I'm going to segue into the treaty because it's most important. I read the Dred Scott case so y'all can get the fundamentals. The Dred Scott case gives you fundamental of every so-called black person, African American, Negro, colored issue, right? As well as why Moors won't get favorable replies in a court system that is quasi to them, which means fake to them. Treaty of Peace and Friendship. And the reasons why I'm going here is because the Constitution of the United States pledges the federal government to protect treaty rights as it is included as the supreme laws of the land. See Constitution Article 6, Clause 2. That clause says what? I'll read it real quick. I have it all in the same spot. Article 6. This Constitution and the laws of the United States, which shall be made in pursuance thereof, and all treaties made, or which shall be made under the authority of the United States, shall be the supreme law of the land, and the judges in every state shall be bound thereby. Anything in the Constitution or laws of any state to the contrary is notwithstanding. So no state, as it relates to a foreign national, an alien, can stand if there's a treaty that supersedes it, which this Article 6, Clause 2 says is supreme law of the land. So it's part of every state's municipal law. They don't have a right or authority or jurisdiction to abrogate it in favor of their state statutes. It's against the law. It is treason. It is fraud. It is a prohibited act. Punishable. Now, they do it because we're not standing. They do it because we haven't been operating in our nobility for almost 250 years, has it been? We've been sitting here acting like quasi-citizens, and they've been having fun. Ain't no more fun going on now.
This guy told I'm about to block him.
I don't care what he got to say if it ain't got nothing to do with what we doing.
No, it don't.
They ain't got nothing to do with what we doing, blocking. Ain't got time for Moors that ain't studied. Or so-called black people that jump on the podcast, because I invite a lot of friends. Let me tell you, I got 350 new friend requests by a whole bunch of people coming from the other African continent, because you know all continents are Africa. He was from the other African continent. They were from the other African continent. Got a whole bunch of them. I didn't accept a lot of y'all because I mean, y'all call all types of nights. I ain't going there. All types of times of night, and y'all not appreciative of. I'm over here on the East Coast, and at a certain time, it's just improper. So I can't accept a lot of friend requests coming from over there on that continent because you're not mindful of the time zone difference. Islam? All right. So what does the treaty say as it relates to Moors? And what treaty I'm reading from? The Treaty of Peace and Friendship from September the 16th and October the 1st, 1836, still in force because it's codified in the Treaties at Law, Treaties in Force document prepared from the Department of State on page 309 to 311. Shows you right there that it's still in force and still active, right? Shows you in the Department of State. But guess what document I was reading where as it relates to the Supreme Court? I'm going to go there. Because y'all got to stop playing games. I ain't playing. And these are Supreme Court justices that are saying, that are asserting that treaties are solemn engagements entered into between independent nations for the common advancement of their interests and interests of civilization. Chief Justice Taney said that a treaty, insofar as the courts were concerned, was a law made by the proper authority. Declared that a treaty was primarily a contract between two independent nations, a very practically the same as expressed by Brown, Justice Brown. For insofar as the court is concerned, we're talking about the Supreme, a treaty is a law to which the court at present refers by citing the statutes of the United States. The Supreme Court has accepted treaty as they are proclaimed. That is to say, whatever is designed as a treaty by the political departments in which are vested the treaty-making power will be considered by the court. A treaty under the municipal law of the United States is a compact or an agreement existing between the United States and certain other independent or semi-independent nations conforming to the constitutional requirements and proclaimed as part of the law of the United States. Supreme Court accepts as the authentic text of treaties that are found in the proclamation published with the statutes of large of the United States and does not refer to the treaty series of the State's Department. Ain't that funny? They're only telling you got to look at it in the laws, in the statutes at large for the United States for them to give it recognition. Have we done that? Yeah, because we give a certified copy from the Library of Congress, validating that the treaty we're enforcing as it relates to Moors is still binding and it's in the law codified, the public statutes at large. And let me go even a little bit deeper to tell you where. The Treaty of Peace and Friendship between the United States and the Moroccans, the Moors, is codified under 8 Stat 100 and 8 Stat 484. That's codified in the public statutes at large of the United States, volume 8. And they're telling you what pages they are on, page 100 to 104, which is the original treaty from 1787, put into perpetuity, meaning it will never, unless we, the nationals, dissolve that agreement. On page 484 to 487, which is where the what do you call it? The renewed or the renewing of and them putting it into perpetuity in 1836. So it's in the law, the Treaty of Peace and Friendship between His Imperial Majesty, the Emperor of Morocco, and the United States of America. And under Articles 20 and 21, it lets you know how claims between United States citizens or those under the protection of the United States citizens, and that would be everybody who went through naturalization. If you're a foreigner from another nation and you went through the naturalization process, you are considered property of the United States of America.
There you go.
That's all y'all who came over here. Every last one of y'all from Africa, all those other continents. and y'all got naturalized, y'all are property of the United States of America. Through that naturalization process, read it. If you didn't read it the first time you signed it. You actually have a binding contract. You better void it. Article 20. If any of the citizens of the United States or any persons under their protection shall have any disputes with each other, the consul shall decide between the parties. And whenever the consul shall require any aid or assistance from our government to enforce his decision, it shall be immediately granted to him. So Article 20 tells you who's supposed to be adjudicating claims against United States citizens and Moors, as well as United States citizens and property of the United States citizens. It's supposed to be the Moorish American Consular Court, the Moors. So when we put our notice of, when Moors put their notice of removals to these quasi courts, and when we in effect send an acceptance and tell you to dismiss that case because you lack authority in the jurisdiction to adjudicate, it's in your best interest to do as the law requires you to do. Or we got to kick it up a notch. Right? Article 21 of the same treaty says, if a citizen of the United States shall kill or wound a Moor, or on the contrary, if a Moor shall kill or wound a citizen of the United States, the law of the country shall take place and equal justice shall be rendered, and the consuls assisting at trial, and if any delinquent shall make his escape, the consul should not be answerable to him in any manner whatsoever. So they're telling you the only things that you can be held criminally liable for. But again, you got to go through the proper venue and the proper jurisdiction in order for that claim to be lodged, right? That's the only criminal claim. Is there any other? So you got all these so-called 50 states trying to put you under the criminal code systems. Moors that are in POW camps. Moors that have outstanding so-called warrants. Moors that have outstanding so-called claims that they're constantly going to family court, traffic court, transportation court. I mean, they actually got drug court. I ain't never heard that. They have all these so-called quasi courts that they're forcing Moors, whether or not you're nationalized or not, to come into those venues to be adjudicated, all fraud. They know it. They didn't know it. They got public notification today. This broadcast is for all Moors, non-Moors, judiciaries, judges, administrators, all these people claiming to be within a specific jurisdiction. This is public notice for everybody to get in line with the laws of the land. The supreme laws of the land. Because to be outside of the supreme laws of the land is to be an outlaw, bandit, and a terrorist. We talked about that almost 3 years ago. You're an outlaw, bandit, and a terrorist if you're not submission. If you don't give 100 submission to the supreme law of the land. I don't have the court cases as it relates to when a so-called state statute tries to go up against a treaty. That's just like a pawn going up against an empress. Where's my empress? Islam. So I read that to say the courts don't have jurisdiction. The state courts do not have jurisdiction to adjudicate cases where a foreign national is involved. Right? No matter what the implications or the presumptions are. They know this as soon as you start saying you're a Moorish American national. They know they're outside of their jurisdiction. And their only lawful position is to dismiss for lack of jurisdiction. All these court cases are saying, oh, we don't got no jurisdiction over that. You shouldn't have to you shouldn't have to ask them to dismiss. They have no choice but to dismiss. And any action done outside of that is null and void anyway. An error in passing a judgment upon the merits in favor of either party in cases which it was not authorized to try and over which it had no jurisdiction is a grave error as any court can commit. It is prohibited by law from doing so pursuant to the Constitution. It is an act of treason. It cannot pass judgment between parties when jurisdiction has been challenged. So when you challenge jurisdiction, everything ceases to exist. Every action is nullified when you challenge jurisdiction. This is why before you put your notices of removals, Moors, you have to challenge the jurisdiction of the court. Quasi-court. It's quasi to you. It's a court to a citizen under their hegemony, but it's quasi to you. I make these distinctions because you need me to make them for you. The 25th section of the Judiciary Act, to renew the case from the state court. The United States courts, writ of errors, must have jurisdiction. If not, the court cannot criticize, cannot controvert, or give an opinion upon the merits of a case from a state court. So when you're in a state court, you can't go through a higher state court. Like let's take for instance, when you go through the appellate, they say, oh, you got to go through the administrative procedures in order to get the case dismissed. If you're a foreign national and the treaty supersedes these state statutes, you're not even supposed to be in that venue. You got to kick it up to the federal courts, to the district courts, to get that case remanded back down and forced to be dismissed within that corporate structure. Right? It's the only choice they have. The federal courts, if the facts appearing on the record show that the state court had no jurisdiction, its judgment will be reversed in the appellate court for that cause and the case remanded with directives to be dismissed. That's kind of what I just said. Islam? And what's a treaty? International law, a compact between two or more independent nations with a view to the public welfare. An argument, a league, or contract between two or more nations or sovereigns, formally signed by commissioners, properly authorized and solemnly ratified by several sovereigns of the supreme powers of each of those states. Material fact number 4. I'm going slow, y'all. Goodness. The Act of Congress declared that slaves and involuntary servitude, except as a punishment for crimes, shall forever be prohibited in all parts of the territory. Now, when they talk about territory, again, they're talking about the United States territories, not the states. So this is letting you know that the Act of Congress, through the so-called territories that are not currently parts added into the state unions, right? So before in the original United States of America, they had 13 colonies, y'all, and then added how many more? Was that 47 or is it 37? So they added about 37 more states, but before they were states, they were territories. So those territories were under the direct jurisdiction of the United States, federal territory, because they were not currently admitted into the states of the Union. So that's why they were not subject to those laws, and they could free slaves if they were brought into their jurisdiction under the United States under the federal district, because it was under the federal district, right? So if they talk about Louisiana in the case and then if you want to go more specifically, they talk about the Northwest Ordinance of 1787. Some people try to say that it wasn't constitutional. Some people said that it was. But we got to understand that prior to the Constitution for the United States of America, they had a whole bunch of treaties, bilateral agreements that were still in force. And the Northwest Ordinance was one of them. And if you look at the date, it was 1787. Constitution was signed at different times by different states. And when they signed on, they automatically orphaned in all those states. And it talks about that in the Constitution. Let me think about what part of the Constitution where it talks about treaties made or all the other preceding arguments. And I don't have that highlighted, but it is in the Constitution where it talks about that. And I don't want to look for it. It says it somewhere, y'all. Somebody can post where it says it, so I don't have to kind of look for it. And I'm not going to look for it. When I find it, I'll post it on in the social platforms, because all laws prior to the Constitution are also binding on the United States, because they're all, unless they have been repealed by 2/3 of the Senate and the Congress, they are still active, positive laws as it relates to the United States. Islam? Material fact number 5. The Constitution declared that all treaties made or which shall be made are the supreme laws of the land.